Hi, I'm Dan Cooperstein, and welcome to this episode of Compliance Minute. On May 17, 2016, the Equal Employment Opportunity Commission, or EEOC, published long-awaited final regulations that describe how employer-sponsored wellness plans can comply with the Americans with Disabilities Act, or ADA, and the Genetic Information Non-Discrimination Act, or GINA. This development was really two big developments wrapped into one because two separate sets of final rules were released. One regulation was issued under Title I of the ADA, which prohibits employment discrimination on the basis of disability, and the other regulation was issued under Title II of GINA, which prohibits employment discrimination on the basis of genetic information. The two new regulations contain important clarifications about the extent to which employers can use incentives and penalties, referred to as inducements, to encourage employees and their family members to participate in wellness programs without violating the ADA or GINA. The good news is that HR and benefits managers can now take a big sigh of relief, as these final rules clarify many of the areas where things just didn't match up. While there's still some lingering questions out there not addressed by the final regulations, let's take a look, at least for this episode, at some of the big clarifications in the final regulations. First of all, the rules on the 30% maximum incentive limit were clarified. Under the new rules, while the 30% incentive limit continues to apply to self-only coverage only, the new rules explain the application of this rule in greater detail and with respect to various program designs, including when participation in the wellness program depends on enrollment in the employer's group health plan. Additionally, the EEOC reasserts its position that the bona fide benefit plan safe harbor does not apply to a wellness plan that includes medical examinations or disability-related inquiries. Under this ADA safe harbor, employers can, without violating the ADA, require employees to take biometric screenings, HRAs, and other medical examinations before being allowed to enter into the health plan, so long as the screening or other exam that's used is used for underwriting risks, classifying risks, or administering risks for a health plan. Similarly, the new final rules keep the requirement from the proposed rules that coverage under the health plan or a particular benefit package under the health plan may not be denied because of non-participation in the wellness program. Another important clarification is that incentives cannot be used with respect to children, regardless of the age of the child. So keep those kids off your wellness plan, even if they're covered dependents on the health plan. Notably, there are a couple of big things that the final rules did not do. The final rules did not permit an increase to a 50% incentive limit for tobacco cessation programs, as some had expected, and which would have made it consistent with the HIPAA ACA rules on wellness plans. The key difference to keep in mind is that the HIPAA ACA rules on wellness plans still apply for wellness plans that do not contain medical examinations or disability-related inquiries. Accordingly, if a wellness plan's tobacco cessation program requires just an affidavit saying that you are or saying that you're not a smoker, then the employer can still utilize a 50% incentive limit. However, if the wellness plan contains a blood test for nicotine or any other kind of similar type of medical examination, the maximum incentive limit must be 30%. Also, another significant omission from the final rules is that the new rules do not require employers to obtain from their employees a prior written authorization about the fact that their participation in the wellness plan or program is voluntary. This was definitely a very significant clarification. So given the complexity of all of these rules and the high cost of getting this wrong, including EEOC audits, lawsuits and penalties, and lawsuits and grievances filed by employees, it's extremely important to speak with your organization's benefits consultant or other trusted advisor to ensure that your organization is getting this right. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.